Let's take a look at a key case within the law of tort. This is the case of Giles and Walker, an old case from 1890 upon the topic of Rylands v Fletcher. In this case, there was a landowner, who was the claimant, and the defendant owned adjoining land. In this case, the claimant's crops and land were damaged by weeds which had grown on the adjoining land. They had spread onto the claimant's land and caused damage. The weeds were growing on the land of the defendant. They had not been planted by the defendant, but they had spread via the wind, which meant that the wild thistle then spread onto the claimant's land, causing considerable damage. The claimant sought an action in Rylands and Fletcher. In this case, the outcome was that the defendant was found not to be liable, and this is because the first element of Rylands and Fletcher requires that the defendant has brought something onto and stored something onto their land that is not naturally found there. Sometimes this is referred to as the accumulation. So in this case, the defendants had not brought anything onto their land. The weeds, the thistle and the seeds were all naturally occurring on the land, so therefore there is no actionable claim in Rylands v Fletcher for something that is naturally collected and occurring on somebody's land. It only applies if the defendant has brought that thing onto the land, and further, the second element of Rylands v Fletcher then requires that the accumulation of that matter on the defendant's land amounts to a non-natural use of that land. Neither of those elements were satisfied in this case, and therefore the defendants were not liable of Rylands v Fletcher.